Good afternoon, Mr. Nolan.
Good afternoon, Paula. How are you?
I'm doing good, thank you. Mr. Tanner has checked in. However, I'm waiting for him to acknowledge that we're here.
Okay.
He's not connected to his audio, so I can't call him.
Okay.
He probably got it set up and then walked away for a few minutes.
I assume so. I've done that myself several times, so.
Yeah. You want to just mute yourself, and then I'm going to go ahead and try to call him and tell him to connect.
Sure.
You are connected, Mr. Tanner. You just need to unmute yourself when the judge comes in, okay? And he's on his way into the courtroom.
Good afternoon, gentlemen.
Good afternoon, Judge.
Good afternoon, Your Honor.
I do have Taikisha Bigham in the waiting room. You want me to bring her in, Judge?
Counsel, you want your client in?
I don't need her to be in. I don't think she necessarily wants to be in. I was asked if she could be excused, and I think she'd just as soon go if she's able to. Do you want me to? Yeah, actually, let me keep her standing by. I'm sorry.
That's fine. We'll put her.
Yeah.
We'll leave her in the waiting room.
Okay.
All right. Appearances for the file.
Wilson Tanner appearing with and on behalf, for the purposes of this meeting, with Taikisha Bingham.
Your Honor, Shane Owen on behalf of the prosecution for the city of Belleville.
All right. All right, gentlemen, I had a chance to read everything. Let's hit the high points and get to argument.
I'll go. I think we've spoken earlier today, and I'm going to rely for the most part on my brief. I think that there has been the answer, the question of consent. I believe at the hearing, as well as in the brief, the argument and the evidence points to the fact that consent is alleged to have been made by virtue of the taking of the test. In other words, she took the test, that was her consent. In my brief, I've outlined that that is not sufficient, acquiescence is not sufficient consent. I would ask the court to recognize that that's what the case law shows, and that rule that there was not consent in this case. I will concede that that there were evidentiary problems for the prosecution in this case because of the time that passed and the understandably imperfect memory after all that time of the officer. That said, it doesn't change the requirement of presenting evidence that there was a lack of consent. I will ask the court at this time if the court wants me to go on and explain further why I believe that even if there had been consent, the FSTs, the testimony of the FSTs didn't provide probable cause, or if the court would like to wait on that or believes it's not necessary at all. If we get to the point where the court rules that the at this point there was enough presented at least to raise a question as to whether the FSTs do, and we get to that point, then I reserve the right to call the expert to explain why the FSTs did not. Yeah,
I want to give Mr. Nolan a chance to respond to the acquiescence is not enough argument.
Okay.
Your Honor, and as I indicated, I would, when I spoke with Mr. Tanner earlier, this does not address your specific question, but as it relates to the FSTs, which aren't necessarily an issue for today, I wanted to acknowledge, pursuant to my ethical duty, that it was indicated in my brief that Miss Bigham, during the one-leg stand test, at least per the officer's recollection, had put her foot down during that test. I did take a look at the video again. It does look like unequivocally she did not in that 30 seconds. So again, I understand that's not an issue today, but I did want to bring that to the court's attention.
Appreciated.
As to the acquiescence argument, first, I would say that the officer was well within her rights to request a PBT. I mean, the statute on point is MCL 257.625A subsection 2, which requires or indicates that an officer may require a PBT on reasonable cause. I think there was ample reasonable cause here. The defendant was speeding. She was driving erratically. When the officer presented up to the defendant's window, she detected the odor of intoxicants. Defendant, beyond that, and probably most importantly, admitted to having consumed alcohol. We're talking the early morning hours after the 4th of July. And when the officer asked her if she would take the PBT, she did. At least as the first PBT, she was given ample time to think about her options, as it was her legal right not to take the PBT. And she voluntarily consented it in hopes that she would pass and be able to go on to her friend's house. As the officer indicated, there was certainly no force or coercion. I don't know, I guess I respectfully disagree with the acquiescence argument. And I mean, with regard to both the first PBT and the second PBT, at no point in time was was the defendant in custody or under arrest.
Let me interrupt you, Mr. Nolan, because if I understand Mr. Tanner's argument, he's saying that the case law, Childbury, I'm not sure how you say that, and others, requires that the defendant actually say, yes, I will, or words to that effect. Just taking the test when asked is not enough. Do you disagree with that conclusion from the case law?
I don't consent with that conclusion.
Well, you got to make a choice. You can either agree with it or you can disagree with it.
I disagree with it.
All right, let's talk about that. Why?
I guess based on the evidence that I believe was presented, that the consent here was unequivocal, specific, and freely intelligently given. I don't see how this was involuntary. It wasn't as if she needed to have her rights explained to her. Implied consent is not applicable as to PBTs here. And again, I think the officer was well within her rights to request the BBT. And I think the officer's testimony indicates that Miss Bigham voluntarily chose to take that test, not once, but twice. So,
Mr. Tanner, why do you think she actually has to say the words, "I will do that," or something to that effect?
Well, I don't, it's a little unclear as to exactly what she does need to do. And I think she does not need to verbatim say, "I will do that." I do think, however, that first of all, I'll address the whether or not there was any duress of any kind. She's an armed police officer with a weapon showing, and she's not allowed to leave. I read that you can leave. May I leave? Not unless you take a PBT. That's some duress right there. But see, the case law is very clear that acquiescence is not enough. There needs to be some form of consent. None is offered. And this consent can't be acquiescence, which is the only offer of consent in this case.
Well, give me an example from some of the case law of something other than words that say, "Yes, I would love to take your PBT."
I think, well, other than words, I don't know if there needs to be words. If somebody would say, "Sure, I'll do it," maybe that would. The answer is, Your Honor, I don't know. I don't see in the case law what it says is sufficient. I didn't actually research what would be sufficient because there's nothing offered as to what she did other than take the PBT.
Okay.
That's the entire argument I saw. That's the argument I researched and developed. And
Mr. Nolan, do you think that Mr. Tanner is misinterpreting that line of case law about acquiescence?
I don't think that you need to have some affirmative statement or affirmative inquiry first from the officer, "Will you take this PBT?" and then affirmative statement from the suspect in question, say, "Yes, I will take this PBT." I don't think in this instance it's mere acquiescence just because she indicated to Miss Bigham that she could, if she took the PBT, she'd be free to go on to her friend's party. I think that was, if you consider the circumstances at issue, Miss Bigham had already arrived at her location. She was already in the parking lot, and she indicated that, "I'm going to go over to my friend's house." But again, I don't know.
But I don't think you answered my question. Mr. Tanner tells me that the case law requires something more than acquiescence. I think we can all agree that acquiescence is when you're asked to do something, you just do it and there's no further conversation. Would we agree with that definition of acquiescence?
Yes.
Mr. Tanner?
I do agree with that.
Okay. So my question for Mr. Nolan is, I don't remember anything from the testimony that gave me anything more than acquiescence. So my question for you is, do you disagree with Mr. Tanner's application of the case law that requires more than acquiescence?
I understand.
I want to argue that. Why do you disagree that more than acquiescence is not necessary?
I don't disagree that more than acquiescence is.
Okay, then tell me what we had in this case that was more than acquiescence.
Well, I think the issue we do have here is we're having an officer who was testifying as to an event a couple of years after the fact. So I do think that memory was an issue with regard to what she recalls in terms of consent. I don't think it ever crossed her mind that maybe this was non-consensual. So I guess to the extent, if you, based on the officer's testimony alone, you believe that's not enough, then I guess I would ask that the video be considered, which I understand would not end this today, but I don't know what other evidence I can point to other than the officer's testimony 2 years after the fact.
Okay, but you watched the video. Is there anything in there that you think would be more than acquiescence?
In watching the video, I thought the officers were extremely polite, as do I think Miss Bigham was as well. I don't.
I don't think that's in disagreement with anyone.
Well, I guess I don't know what the officer's alternative is, unless in every situation they need to specifically ask, "I'm going to request that you take this PBT, as is my right under law. It's also your right not to take this PBT, but in that situation, will you still take it?" That's not required. The law doesn't require that. The law indicates that the officers may require an individual to take a PBT test if there's reasonable cause. There was reasonable cause here. So
okay, but you've just agreed with me that the law requires more than acquiescence. And the only thing I can come up with, and I'm waiting for you two to give me something other than my thought process, the only thing I can come up with that's more than acquiescence is somebody saying, verbalizing somehow, way, shape, or form that they've agreed to do so. So you've agreed that acquiescence is not enough. So tell me what would be enough other than verbiage.
I think taking the test voluntarily, knowingly, and willingly, which I think is all borne out in the evidence here.
Isn't that acquiescence?
Then anytime anybody takes a PBT, it's acquiescence. So I guess I'm at a loss as for what exactly is required.
And I'm not prosecuting this case. And I'm giving you all kinds of reasons to give me something to hang my hat on if you want this to go forward.
Like I
You've
said,
agreed that more than acquiescence is necessary, but you haven't given me anything in this case that's more than acquiescence. Did you research it? I'm assuming you read the same case law Mr. Tanner did.
I did. I guess the only thing I can point to is the video evidence. So if the court doesn't think that the testimony is sufficient as to the acquiescence issue, then
And
I would ask.
Mr. Nolan, I've asked you, what is there in the video that gives me something more than just her doing it?
All right. So the first time she's asked to take the PBT, this is after the officer goes up to her window, detects the odor of alcohol, asks Miss Bigham if she's been drinking. She indicates, yes, I had been drinking earlier in the day. I think she said I had 1 or 2 beers. At that point in time, the officer asked her if she was willing to take a PBT. She goes back to her car. She sets up the device, and about a minute or 2 later, she shows back up at Miss Bigham's window, and she proceeds to give her the PBT. So
Stop right there. And I'm not trying to make Mr. Tanner's argument. I'm just trying to figure out where you're coming from. Isn't what the defendant did at that point acquiescence?
She complied with the request. So I guess that would be acquiescence, but I think it was beyond acquiescing. I think she still had an opportunity to consider her rights and either refuse to take the PBT or go ahead and do so, and she did so.
Your Honor, I need to object to the hearsay, but I'm not object. I understand the argument. It's obviously the video isn't in. I can tell you that I don't have a problem with it, but I would be remiss if I didn't object to the prosecutor testifying as to what the video that is not admitted showed. But I don't think there's anything that anybody can say about the video that's going to show more than acquiescence.
I have no further comment. Sorry.
I'm sorry, Mr. Nolan.
I said I have nothing else to add. I understand I'm beating a dead horse, and I'm probably not answering your question as the way you want it. And you've given me more than enough opportunity, and I appreciate that. I just don't know what else I can say based on the testimony that was presented.
I don't either, because what I've got is I got both sides, which doesn't happen very often, but I got both sides agreeing on the crux of the argument, which is acquiescence is not enough. And I haven't heard any reason, any indication that there was anything more in this situation than acquiescence. So I guess it's not coming in.
Okay.
So where are we at with this? Do we have a trial date set?
Not yet.
I think not.
All right. So do you want, well, I still got Bingham. You guys want to pre-try this case now, or you ready for a trial date? What are we going to do?
I'd ask to dismiss I'd ask you to grant the motion to suppress. And
I just did. I said it's not coming in. That's suppression.
Oh, okay. All right.
But that doesn't end it. I mean, that suppresses the PBT.
Yeah, doesn't kill the case.
Sobriety test. So
yeah, it doesn't kill the case.
I've had an impaired plea on the table from the get-go. So I understand. Me and Mr. Tanner had talked about having a conditional plea. Depending on what you did today, she could still, per her right, appeal to the higher court, at least on the consent issue. But now that's really not a problem. So I don't know where we stand. I just know that if beyond here, it sounds like he's going to call an expert to testify as to the field sobriety test. And then beyond that, if we go that far, then we're looking at trial. So
the field sobriety test, as I understand it, would be suppressed as well. They're fruit of the poisonous tree. She's testified on the record.
I disagree with that.
She testified on the record that she would not have, would have let her go and wouldn't have done the field sobriety test, but for the first PBT. That's in evidence.
Yeah, but fruit of the poisonous tree is my decision to make, and she had plenty of reason to do FSTs, even if Miss Tanner or Miss Bingham would have said, "I'm not taking that PBT." There was probable cause to go to the FSTs just by if nothing else, the fact that the woman admitted that she was drinking.
Well, I can argue that as well. There's a case albeit not published. It's Ricky Edwards, I think it is. And I can get you the citation that shows that with considerably more evidence than what was provided, it was a close, well, I guess that actually argues the PBTs. I think that just saying that she had 1 or 2 drinks isn't sufficient to require FSTs. And I think that FSTs wouldn't have, well, I think she did the FSTs. And if we got to go forward and show that, the FSTs showed not, even if they're admitted, they did not show impairment. They showed the lack thereof. She stood on, well, as an offer of proof.
Then let's try the case. Let's, seriously, guys, we've spent more time on this than most 2 drunk driving trials I hold. Let's set a trial. Let's bring your expert in. Let the trier of fact, whoever that is, make a decision.
I'm fine with that.
If that's what we have to do, we have an alternative, I guess.
What's that?
And we'll have to talk to my client briefly about this, but I talked to both attorneys, by the way, Judge, are in complete agreement with you that this case needs to end somehow. My client's been out on bond for, close to 2 years. She's certainly being prejudiced. Both sides are being prejudiced by the delay, but she's been, again, on bond and allotted more duress than either attorney or the court has, obviously. We anticipated that, frankly, that the FSTs would be suppressed and we wouldn't have to go forward with that at this point. If the court is not going to rule like that, I would talk to my client about a conditional plea. I talked to the prosecutor about it already. It's not the plea it's not the circumstances we anticipated. We thought you would either suppress the evidence that followed the first PBT or not, if depending on the consent ruling.
You want a breakout room with her? Because she's still in the waiting room.
I think that makes sense. And then I will ask for a very quick breakout room with Mr. Nolan as well.
All right, Paula?
I'm bringing her in, Judge.
Paula will make that happen, fellas.
Thank you.
Ms. Biga, we've brought you in. You're going to go into a breakout room momentarily with your attorney, okay? That's a private room where you can discuss. Hang on just a moment.
Thank you.
You're welcome. And then when they come back in, I guess he wants to go in a breakout room with you, Shane.
Okay, that works.
Okay, thank you.
Yep.
Dane,
Yep,
do you want to talk for a minute?
sure.
Okay. Paula, are you able to affect that?
Yes, Mr. Tanner, I'm going to put the two of you in a breakout room now. Did your client hang up?
I hope not.
Well, I don't see her, and she's not on the screen.
Okay. She said she was going to wait in the breakout room.
Oh, okay. Well, she's going to get kicked out in just a second here.
Okay.
She can't stay in there. So
Okay.
hang on. I'll
Well,
bring her
maybe
in.
I don't. Yeah. Okay.
She'll be in about 6 seconds. Hang on. I'm so sorry, honey. If you just hang on a second. Okay. Okay, she's coming back in. So we're just going to ask her to mute herself, and I'll put the two of you in a breakout room.
Thank you.
Miss Bigham, they'll be back shortly. Okay.
Okay, thank you.
You're welcome.
Hello?
Hi, Ty. I think you can see me. We're gonna, I've spoken to the prosecutor. I can talk to you more, but the prosecutor would like to have what amounts to a bench conference with the judge, which would look like we walk up to the bench, but in fact, it'll be a breakout room.
Okay.
So I will leave it at that for now.
Okay.
You all right?
Yeah. Just
Not
tired.
really.
I'm just tired. I didn't get home from work until about 5 or 5:30. So
Oh, my goodness. I'm sorry. I think
yeah,
your
it's all good.
I think your presence would be waived at this point. But I could
Okay.
ask. Would you like to get going?
Yeah, I'd like to take a nap before I have to go back to work at 4.
Let me ask that. All right.
Okay, thank you.
Kind of what happened to
Hi, Mr. Tanner, hang on just a second. Judge will be right back.
yeah,
And
hey,
Shane is probably still in the breakout room.
with me,
Hang on.
Paula,
Yeah.
my client, Miss Bingham, got off work at 5 this morning and goes back to work at 4 and would love to take a nap first. I'm going to ask.
Okay, Judge is going to be, he's coming on right now.
Sure. Oh, okay. All right.
And it looks like we lost well, no, he's in the waiting room. Okay.
Maybe I can. Oh, all right. I'm going to wait till Shane gets back and ask the judge.
He
Judge,
is now.
Go ahead.
Miss Bingham got off work at 5 in the
I
morning.
heard all that. I heard that. Ask your request.
Okay. Oh, may she be excused?
Yeah,
From
what
the
are we
rest-
gonna do what are we gonna do?
What we'd like to do is, I think Shane would like, Mr. Nolan, I think would like to have a short bench conference, but in short, we would like time for him to be able to talk to his client and my client to talk to her parents.
So why don't we just do this? Why don't we'll set an in-house review for a couple weeks out with the idea you guys are gonna talk to, give Paul a call and get us back on Zoom.
I hope to have an answer by the end of the day. So
That's fine. That's fine.
And we'll
Set it for an in-house. Miss Bingham, you can take off. We'll set it for an in-house review so we don't let the file fall through the cracks, and I'll expect you two to get something going with Paula.
I appreciate that.
Awesome. All right.
Okay.
Thank you, gentlemen.
Thank
Shane,
you.
thank you very much, Judge. I'll get back to you, Shane, and if we can get her in earlier, we'll do it
Sounds good.
if it's possible. Thank you, Your Honor.
Thank you.
You're welcome.
Judge, do you want me to take you off YouTube?